You people always want something for nothing. Get out of my building before I have you removed in handcuffs." The words hung in the air like smoke from a gun. The woman behind the reception desk didn't flinch, didn't blink, didn't move. She simply stood there, worn handbag over one shoulder, a crumpled paper clutched in her hand, while Bradley Hartwell III, grandson of the firm's founder, heir to a legal dynasty built on old money and older prejudices, stepped closer until his shadow swallowed hers whole. He had made a mistake, a $14 million mistake. He just didn't know it yet. The lobby of Hartwell and Associates gleamed with the kind of wealth that announced itself without speaking. Italian marble floors, original artwork on the walls, leather furniture that cost more than most people's cars. And in the center of it all, a black woman in a faded blouse and scuffed shoes, holding a notice that would determine her son's future. "I have a legal matter." Her voice came out steady, controlled. "My son's school hearing is in 5 days. I need representation." Bradley's laugh was short and ugly. "Lady, I don't care if your son is being shipped to prison tomorrow. This firm has standards, and you—" He looked her up and down with the kind of assessment that reduced a person to their clothes, their shoes, the neighborhood they probably came from. "You don't meet them." Behind the reception desk, Heather Ashby watched with a small smile. She'd seen this before. They all had. The founder's grandson had a particular talent for making people feel small, for reminding them of their place, for enforcing the invisible lines that kept certain clients out and certain money in. What none of them knew, not Bradley with his inherited arrogance, not Heather with her gatekeeping smile, not the security guard already reaching for his radio, was that the woman standing in their lobby had signed the papers 3 days ago. The acquisition was complete. The firm they thought belonged to them now belonged to her. And she had been watching them for 3 months. If you're already hooked by this satisfying confrontation, hit that subscribe button, because what happens next will shock you. 72 hours earlier, the apartment in Decatur sat quiet in the early morning light, a 2-bedroom unit in a building that was clean but not fancy, safe but not luxurious. Ivory Mercer sat at her kitchen table, laptop open, spreadsheet filling the screen with numbers that told a story no one was supposed to see. Her son Marcus was in the living room, head bent over homework, pencil scratching against paper. 14 years old, honor roll, art club. The kind of kid who stayed out of trouble because he understood, even at his age, that trouble found black boys whether they went looking for it or not. Ivory's eyes moved across the data. 847 potential clients over 18 months. Intake requests, sorted by name, by date, by demographic information that the firm claimed not to track, but somehow appeared in the metadata of every record. She'd found it during due diligence, a hidden field in their intake software, a checkbox that wasn't supposed to exist. Race. 312 black potential clients had approached Hartwell and Associates in the past year and a half. 23 had been accepted, 7.4%. She'd run the numbers 4 times, each time hoping she'd made a mistake. She hadn't. White clients in the same income bracket, 68% acceptance rate. The disparity wasn't random. It wasn't coincidence. It was policy. Her phone buzzed. An email notification from Fern Holloway, a paralegal she'd never met in person, but who had been feeding her information for weeks now. The subject line read, "Intake statistics, confidential." Ivory opened the attachment and read the cover note. "Miss Mercer, attached are the client intake records you requested. I've highlighted the patterns you'll want to see. Please be careful." Please be careful. Such a small phrase to carry so much weight. "Mom?" Marcus had appeared in the kitchen doorway, backpack slung over one shoulder, expression uncertain in a way that made him look younger than his years. "You're still in your robe. You never stay in your robe this late." Ivory closed the laptop and smiled, the automatic, reassuring smile that every mother learned to deploy when her child needed to believe everything was fine. "Just working from home today. Have a good day at school." "Mom," he hesitated. "About what happened, with the box cutter." I didn't. I know, baby. I know you didn't do anything wrong. Mr. Hendricks saw me use it in class, for my art project. He can tell them. Marcus. She stood up, crossed to him, put her hands on his shoulders. I know. I've read the incident report. I've seen the inconsistencies. We're going to fix this, okay? That's what I do. I fix things. He searched her face for something. Reassurance, maybe? Or that particular kind of certainty that parents were supposed to have but so rarely did. What if they don't believe me? What if they don't believe any black kid who says he didn't do it? The question hit her like a fist. Not because it was unfair, but because it was so painfully, precisely accurate. He was 14 years old, and he already understood how the system worked, how the presumption of innocence only seemed to apply to certain people, how the benefit of the doubt was a privilege extended to some and denied to others. Then we make them believe, she said, with evidence, with documentation, with facts they can't ignore. He nodded, though the uncertainty didn't leave his eyes. Then he was gone, out the door, off to a school that was trying to expel him for having school property in his possession. The irony was almost too bitter to swallow. Ivory stood alone in her kitchen, coffee going cold, laptop waiting. She had work to do, $14 million worth of work. The phone rang. Mercer Legal Group, her firm, the one she'd built from nothing over 15 years, the one that had grown from a solo practice in a strip mall office to a mid-sized civil rights firm with 23 attorneys and a reputation for taking cases no one else would touch. Ms. Mercer, her assistant's voice was crisp, professional. The Hartwell closing documents are ready for final review. Send them to my secure email. I'll sign tonight. Ma'am, are you sure about this acquisition? Some of the partners have concerns about... I'm sure. She hung up before more questions could follow. Her partners didn't know the real reason she was buying Hartwell & Associates. They thought it was a strategic expansion, a way to add a family law practice to their portfolio, a smart business move that would pay dividends for years. And it was all of those things. But it was also revenge, the kind of revenge that came with receipts. The first visit happened on Monday. Ivory chose her outfit carefully. Blouse from Target, 3 years old with a small stain on the cuff she'd never quite gotten out. Jeans that had faded from wear rather than fashion. Flats with scuffed toes. No jewelry except the small gold studs her mother had given her for her 18th birthday. She looked like what they expected her to be, what they needed her to be for this to work. The lobby of Hartwell & Associates was everything she'd expected from the photos in the acquisition file, all glass and stone and aggressive professionalism. The receptionist sat behind a curved desk of polished wood, blonde hair perfect, makeup impeccable, smile automatic and empty. Heather Ashby. Ivory had read her personnel file, 10 years with the firm, started as a temp, worked her way up to senior intake coordinator, exemplary performance reviews, every single one praising her commitment to maintaining firm standards and her excellent judgment in client selection. Translated, she knew which clients to let in and which to turn away, and she'd gotten very good at the turning away. Can I help you? The assessment was instant and obvious, eyes traveling from Ivory's face to her clothes to her bag to her shoes, the mental calculation happening in real time. Not wealthy, not connected, not someone who could pay their rates or enhance their reputation, not welcome. I'd like to speak with someone about a school disciplinary case. My son, we're booked solid for consultations. The words came fast, practiced. I can put you on the wait list. Might be 3-4 weeks. Ivory didn't react, didn't let her expression change, but she noted the lie. She'd reviewed the firm's scheduling system as part of due diligence. There were 3 open slots this week alone, gaps in the calendar that should have been filled. 3 or 4 weeks might be too late. His hearing is Friday. I'm sorry. The smile didn't change. That's really not something I can control. Our attorneys are very busy. If you'd like, I can recommend some other firms that might be more suited to your situation. There it was. That word. Situation. A polite way of saying what couldn't be said out loud, that Ivory's situation was her skin color, her apparent class status, her failure to be the kind of client who belonged in a lobby like this. Could I leave my information, in case something opens up? Heather's smile tightened almost imperceptibly. Of course. Fill out this form and I'll make sure someone reviews it. The form was intake paperwork. 3 pages of personal information, employment history, income documentation requests. Ivory filled it out with a name and address that matched her real identity, but revealed nothing about who she actually was. She wrote her occupation as consultant and her income as variable. Both technically true. When she handed it back, Heather glanced at it once and set it aside, not in the intake tray, where pending requests were sorted for attorney review, in a different pile, the pile that never moved. We'll be in touch. They wouldn't be. Ivory knew that. They both knew it. But the ritual had been observed, the dance performed, and now Ivory could leave with her documentation, a time-stamped form, a witness who had watched Heather set it aside, a starting point for the pattern she was building. She was almost to the door when she heard it, a voice from the hallway, male, irritated, speaking to someone on the phone. Tell her I can fit her in tomorrow at 10. No, not the intake wait list. She's a referral from Judge Morrison. I know we're booked. Move something. Ivory didn't turn around, didn't acknowledge that she'd heard. She simply walked out into the Atlanta sun and started the clock. Day 2. She'd booked an appointment online this time, using the firm's public scheduling system, filling out the form with the same information from her intake paperwork, confirming a 10 a.m. slot for Tuesday morning. The confirmation email sat in her inbox, time-stamped, documented. The lobby was the same. Heather was the same. But there was a new face behind the desk as well, Claudette Vance, office manager, according to the nameplate on her blazer. Ivory had read her file too, 15 years with the firm, the one who kept the books, managed the schedules, made sure the trains ran on time, and, according to Fern Holloway's anonymous reports, the one who handled the adjustments when certain clients needed to be quietly removed from the system. I have a 10 o'clock appointment. Ivory set her phone on the counter, confirmation email visible. My name is Ivory Mercer. Claudette's fingers moved across her keyboard, face neutral, expression giving nothing away. I'm sorry, but I don't see your name in our system. Are you sure you booked with us? I have the confirmation number right here. Claudette leaned in to look at the screen, then leaned back with a small shake of her head. This must be a glitch. Our system shows this slot was already filled, by a different client. I received this confirmation at 6:15 yesterday evening. Your system sent it automatically. Technology. Claudette's smile was sympathetic, conspiratorial, the smile of someone sharing a frustration rather than causing one. It does this sometimes. I'm so sorry for the inconvenience. Would you like to reschedule? I might be able to find something next month. Next month. Her son's hearing was in 4 days. I have documentation of the appointment. Surely there's something. Ma'am? The voice came from the hallway. A man in a gray suit, red tie, the kind of polished professional appearance that cost money to maintain. Derek Foley, associate attorney. His file indicated he was 31, Harvard Law, fast-tracked for partner. Is there a problem here? This woman claims she has an appointment, but I don't claim anything. Ivory kept her voice level. I have a confirmation email from your own system. Derek approached the desk, positioning himself beside Claudette, creating a wall of professional authority. Ma'am, our firm has a strict policy. Section 3.2 of our intake protocol requires verified income documentation before any consultation can proceed. Do you have that with you? The lie was so smooth it almost sounded believable. Almost. I'd be happy to provide whatever documentation you need, but I believe income verification comes after initial consultation, according to your own procedures. Something flickered in Derek's eyes, a crack in the professional facade. She'd caught him. Section 3.2 didn't exist, at least not for income verification. She'd read every page of their operating procedures during due diligence. Section 3.2 covered conflict of interest screening, not financial requirements. He couldn't know how she knew that, and his confusion was showing. "I don't know where you got that information, but you're mistaken." He recovered quickly, smoothly, the way lawyers learn to recover when their arguments fell apart. "I'm going to have to ask you to leave and reapply through proper channels." "What proper channels? I used your online system. I received a confirmation. I arrived on time. What additional channel is there?" The question hung in the air. Behind the desk, Heather had stopped pretending to work. A client sitting in the waiting area looked up from her magazine. Somewhere in the back office, a phone rang and went unanswered. "Ma'am?" Derek's voice hardened. "I'm asking you to leave. If you refuse, I'll have to call security." "On what grounds? I'm a potential client with a confirmed appointment. What specific policy am I violating?" He didn't have an answer. Couldn't have an answer because there was no policy. There was only the unwritten rule that people like her weren't supposed to push back, weren't supposed to ask questions, weren't supposed to know their rights. "Security," he said the word toward the back of the office, loud enough to carry. "We have a situation at reception." Ivory didn't move, didn't raise her voice. But she pulled out her phone and began typing, documenting the time, the names, the exact words that had been used. Her fingers moved quickly, professionally, the way someone types when they've spent years producing evidence for court. "What are you doing?" "Taking notes. Is that a problem?" "You can't. Georgia is a one-party consent state. I can document my own conversations." She looked up from the phone, met his eyes directly. "Would you like me to explain what that means?" Before he could answer, Heather spoke from behind the desk. "Mr. Foley, I think we can handle this. Perhaps if Ms." She glanced at the intake form. "Mercer would like to reschedule. We can find a time that works better for everyone." The de-escalation was obvious. Strategic. They wanted her out without a scene, without witnesses to whatever came next, without any more questions that didn't have good answers. Ivory let the silence stretch for 3 full seconds, long enough to be uncomfortable, short enough not to seem unreasonable. "I'll reschedule," she said finally. "But I want a written confirmation this time. Email and paper copy. And I want the name of the supervising attorney who will be handling my intake." Claudette's smile didn't reach her eyes. "Of course. We'll have that ready for you." They wouldn't. Ivory knew it. They knew it. But the game was being played, the pieces being moved, and every move they made was another piece of evidence in the file she was building. She walked out into the morning sun, 2 visits down, a pattern beginning to emerge. If you think they're going to get away with this, keep watching, because what she found that night changed everything. Wednesday came with rain. Ivory returned to Hartwell & Associates with a folder of documentation, tax returns, bank statements, proof of residence, everything Derek Foley had demanded without legal basis. She'd printed them that morning, organized them by category, labeled each document with tabs that made her look like what they assumed she wasn't: organized, prepared, capable. The lobby was busier today. 3 clients in the waiting area, 2 of them white women in designer clothes, 1 older white man reading the Financial Times. They all looked up when Ivory walked in, then looked away with the practiced disinterest of people who had learned not to see certain others. Heather's expression flickered when she recognized her, something between annoyance and alarm. "You're back. I brought the documentation your colleague requested." Ivory set the folder on the counter. "Tax returns, bank statements, proof of residence, income verification. Everything required under Section 7.1 of your intake procedures." The specific citation was intentional. Section 7.1 actually did cover income documentation, but only after initial consultation, exactly as she'd said. She was showing them she knew their own policies better than they did. Claudette appeared from the back office, moving quickly, intercepting before Heather could respond. "Ms. Mercer, I'm afraid there's been a development." "What kind of development?" I found this in our system. Claudette held up a printed document, official-looking, stamped with the firm's letterhead. A client intake note from your first visit. It appears you were flagged for concerning behavior. Ivory took the paper and read it aloud, slowly, clearly, making sure anyone in earshot could hear. Client intake note, dated October 14th, 10:17 a.m. Potential client Ivory Mercer flagged for aggressive behavior during initial contact. Receptionist Heather Ashby reports client used threatening language and refused to follow standard intake procedures. Recommendation: do not engage. She looked up, met Claudette's eyes, held them. This note is dated October 14th, Monday. My first visit. That's correct. The timestamp says 10:17 a.m. Yes. I arrived at the office at 10:22. I have the parking garage receipt to prove it. This document was created 5 minutes before I entered the building. The silence that followed was surgical, precise. The kind of silence that happened when a lie was exposed, and everyone in the room knew it, but no one was willing to say so out loud. Claudette's face didn't change. Timestamps can be glitchy. I'm sure it's just a technical. May I have a copy of this document for my records? That's confidential internal documentation. It has my name on it. It describes my alleged behavior. Under Georgia law, we're a private firm. Whatever law you're thinking of doesn't apply here. She was right about the technicality, wrong about everything else. But Ivory let it go. For now, she had what she needed, a fabricated document with a timestamp that proved its own falsification. Another piece of evidence, another nail in the coffin. I'd still like to schedule a consultation, she said. I've brought everything you requested. My son's hearing is in 3 days. I'm sorry. Claudette's voice had hardened now, dropped the pretense of sympathy. Based on this intake note, we won't be able to assist you. I'd suggest you try another firm. Can I speak to an attorney about this decision? Our attorneys stand by our intake procedures. I'm asking to speak with one directly. That won't be possible. The voice came from behind Ivory, deep, male, accustomed to being obeyed. She turned to find Bradley Hartwell III standing in the hallway entrance, arms crossed, posture aggressive. He was tall, broad-shouldered, the kind of physically imposing presence that men used when they wanted to remind women of the power differential. My intake coordinator said no, he continued. My office manager said no. I'm saying no. How many times do you need to hear it before it sinks in? Ivory held her ground. I'm asking for legal services. Your firm advertises family law consultations. I have a legitimate case. Lady, I don't care if the Pope himself referred you. He stepped closer. This is my firm. My grandfather built it from nothing. My father grew it into what it is today. And I decide who walks through those doors. Based on what criteria? Based on whatever criteria I want. He was close now, close enough that she could smell his cologne, see the broken capillaries around his nose that suggested too many long lunches with too much scotch. We have a certain clientele here, a reputation. And you don't fit. Don't fit what? The question was a trap. They both knew it. If he answered honestly, he'd incriminate himself. If he lied, the lie would be obvious to everyone watching. He chose neither. Instead, he moved even closer, using his size to intimidate, to crowd her space, to make her feel small and threatened and unwelcome. Get out. Now. Before I have security drag you out. Ivory didn't step back. Didn't flinch. I'm a potential client on business premises during business hours. You have no legal basis to remove me. His hand shot out and grabbed her arm, hard, fingers digging in, the kind of grip that would leave bruises. I said get out. Let go of me. Or what? She didn't struggle, didn't panic, just looked at his hand on her arm, then back at his face, her expression calm in a way that seemed to infuriate him further. You're assaulting me in front of witnesses, your receptionist, your office manager, 3 clients in your waiting area, and the security camera above the door that's been recording since I walked in. His grip tightened for just a moment, a flash of rage that wanted to escalate, to hurt, to show her exactly what happened to people who talked back and then released. He stepped away, hands up, palms out, the gesture of a man who'd suddenly realized he'd made a mistake. "Heather, call security. Get this woman out of my building." "I'll leave voluntarily." Ivory straightened her sleeve where his fingers had crumpled the fabric. "But I want the names and badge numbers of any security personnel involved, and I want documentation of this interaction for my attorney." "Your attorney?" Bradley laughed. The sound was ugly, dismissive. "Lady, you can't even afford ours. What makes you think you have an attorney?" "Everyone has an attorney, Mr. Hartwell. Some of us just haven't met them yet." She walked toward the door, moving slowly, deliberately, giving everyone in the lobby time to see her, to remember her face, to serve as witnesses to what had happened. At the threshold, she paused and turned back. "By the way, you might want to check Section 3.2 of your intake protocols, the one your associate cited yesterday. It covers conflict of interest screening, not income verification. Someone should probably correct that in your training materials." She was gone before anyone could respond. The parking garage was 3 levels of concrete and shadows, her car a modest Honda Civic tucked between a Mercedes and a BMW. She was 20 feet from the driver's door when she heard the footsteps behind her. Bradley Hartwell III emerged from the stairwell, face red, veins visible in his neck. He'd followed her down alone. No security, no witnesses, no cameras that she could see in this corner of the structure. "You think you're smart?" He advanced, hands balled into fists. "You think you can come into my firm and embarrass me in front of my staff? I think I'm a potential client who was denied service without legal cause." "You're nothing." He was close now, too close, backing her against her car. "You hear me? Nothing, a nobody, a welfare case looking for a handout. And if you ever set foot in my building again—" His fist came fast, aimed at her stomach, a gut punch meant to hurt without leaving visible marks. But Ivory had spent 5 years working with the Attorney General's Civil Rights Division. She'd dealt with threats before, had been trained to recognize them, to avoid them, to survive them. She shifted sideways, his fist grazing her ribs instead of landing solid. The momentum carried him forward, off balance, and she used it, stepping past him, creating distance, keeping her car between them. "That's assault, Mr. Hartwell. First one on camera upstairs, second one right here. I'm willing to bet this garage has security footage somewhere." "There's no cameras in this section." His smile was ugly. "I checked." "Then I guess it's your word against mine." She reached for her car door. "Though I should mention, I've been recording audio since I walked out of your lobby. Georgia's one-party consent law. Everything you've said in the last 3 minutes is documented." The color drained from his face. His fists unclenched. For a long moment, he just stared at her, trying to calculate whether she was bluffing, whether the phone in her pocket was actually recording, whether he'd just made everything worse. "Who are you?" The question came out hoarse. "Who the hell are you?" "I'm just a mother trying to find a lawyer for my son." She opened her car door. "Have a nice day, Mr. Hartwell." She drove away without looking back. In her rearview mirror, she could see him standing in the empty space where her car had been, fists clenching and unclenching, trying to decide what had just happened and how badly he'd miscalculated. He had no idea. Not yet. Thursday. Ivory sat in her home office, 3 monitors arranged in a semicircle, each one displaying different data from the Hartwell acquisition files. The bruise on her ribs had bloomed overnight, purple and angry, tender to the touch. She photographed it from multiple angles, documented the time and date, added it to the evidence folder that was growing thicker by the hour. Her phone buzzed. Unknown number. She answered anyway. "Ms. Mercer?" The voice was young, female, nervous. "This is Fern, from the firm. I saw what happened yesterday. The whole office is talking about it." "How did you get this number?" "I looked it up, in the system." A pause, a breath that suggested courage being gathered. Please don't be angry. I wanted you to know you're not the first. There have been others. Dozens of others. Ivory leaned back in her chair. Others like me? People who came in looking for help. People who got turned away for reasons that didn't make sense. I've been keeping records. Copies of intake forms, denial letters, notes I wrote to myself about things I saw. I didn't know what to do with them. I thought maybe someday someone would care. Why are you telling me this? Silence on the line. Then quietly. Ma'am, I don't know who you are, but the way you talked to them yesterday, the way you knew the law, the procedures, the policies. I've worked here 3 years. I've never seen anyone stand up to them like that. Most people just accept it. They walk away. They think they must have done something wrong. Ivory's chest tightened, not from the bruise, from something deeper. The weight of all those people who'd walked away believing the system had judged them fairly when it hadn't. Who'd blamed themselves for a rejection that was never about them at all. Can you meet me? She asked. Somewhere away from the office? Tomorrow morning? There's a coffee shop on Peachtree, 2 blocks from the courthouse. I can be there at 7 before my shift starts. I'll be there. Miss Mercer? Fern's voice dropped even lower. Be careful. They're not going to let this go. Bradley's been in meetings all day. Something's happening. Let it happen, Ivory said. I'm not done yet. The coffee shop was small and crowded, the morning rush creating a wall of noise that made private conversation possible. Fern Holloway sat at a corner table, folder on her lap, eyes darting toward the door every few seconds. She was younger than Ivory had expected, late 20s maybe, with the slightly hunched posture of someone who'd spent too many years trying to be invisible. Ivory slid into the seat across from her. You came. I almost didn't. Fern's hands trembled slightly as she pushed the folder across the table. I've been keeping this for 2 years. Every intake denial that didn't make sense. Every client who got turned away. Every excuse they used. The folder was thick. 3 inches of paper, maybe more. Ivory opened it to the first page. A handwritten log, names and dates and outcomes. Each entry brief but damning. March 2023. Angela Davis, denied for insufficient documentation. A white client with the same documentation was approved the same day. Ivory turned the page. July 2023. Marcus Williams, denied for schedule conflict. But there were 3 empty slots that week. Another page. October 2023. Denise Thompson, denied for case being outside their practice area. But they took an identical case from a white client the following week. The list continued. Page after page of patterns. Evidence. Proof. Why didn't you report this? Ivory asked. To who? Fern's laugh was bitter. The state bar? They protect their own. The partners? They're the ones who set the policy. The media? I'm a paralegal making $40,000 a year. They'd bury me. So why keep the records? Because someone had to. Fern met her eyes for the first time, really met them, without flinching, without looking away. Because someday, someone was going to come along who could do something about it. Someone who knew the law. Someone who had resources. Someone who wasn't afraid of them. Ivory closed the folder. What do you want out of this? I want to keep my job. The answer came fast, honest. I need this job. I have student loans, rent, a mother in a nursing home. I can't afford to be a whistleblower. But if someone else, someone with standing, were to file a complaint, I could testify, under subpoena, where I'd be protected from retaliation. Smart, strategic, the thinking of someone who'd been trapped in a system long enough to learn how it worked and how to survive it. You'll have your subpoena, Ivory said. I can promise you that. Fern's eyes widened. How? Who are you? Someone who made a $14 million investment in getting these people held accountable. Ivory stood, tucking the folder into her bag. Don't contact me again. Don't mention this meeting to anyone. When the time comes, a lawyer will reach out with official documents. Until then, keep doing your job, keep being invisible, and keep being careful." She was at the door when Fern's voice reached her. "Ms. Mercer, thank you for believing me, for caring." Ivory didn't turn around. "Don't thank me yet. This is just the beginning." That night, Ivory sat in her home office and read through the email chain that Fern had flagged in her notes, messages recovered from the firm's server, messages that the senders thought had been deleted. From C. Vance at hartwelllegal.com to H. Ashby at hartwelllegal.com. Date: October 14th, 2024, 4:47 p.m. Subject: Walk-in issue. Just created a file note backdated to this morning. Should cover us if she complains. Made sure to flag her as aggressive. That usually kills any credibility. Ivory screenshot the message, saved it, added it to the evidence folder. Then she opened a new document and began typing. State Bar of Georgia, Office of General Counsel. R.E. Complaint against Hartwell and Associates. Date: October 17th, 2024. The cover letter took an hour to draft. The exhibits took 3 more. By the time she finished, the complaint ran 47 pages. Statistical analysis, internal communications, fabricated documentation, witness statements. Everything organized, indexed, cross-referenced. The work of someone who'd spent 20 years building cases. She signed it, Ivory Mercer, concerned citizen. Not yet revealing her position, not yet showing her hand. The time would come. Friday. Marcus's hearing. Ridgemont Academy occupied 3 buildings on a manicured campus in Buckhead, the kind of private school that charged $40,000 a year and still managed to find reasons to expel black students at twice the rate of their white classmates. The disciplinary hearing room was designed to intimidate. Long table, high back chairs, school crest looming on the wall like a judgment already rendered. Ivory sat beside Marcus, her hand on his arm, both of them facing a panel that included Principal Morrison, 2 board members, and the school's legal counsel. Elena Torres sat on Marcus's other side, a civil rights attorney from a different firm, someone Ivory trusted, someone who didn't know her true identity and couldn't accidentally reveal it. "The matter before us," Principal Morrison began, "concerns the possession of a prohibited item on school grounds, specifically a box cutter discovered in the defendant's—" "My client is a student, not a defendant." Elena's voice cut through cleanly. "This is a disciplinary hearing, not a criminal trial. The terminology matters." Morrison's jaw tightened. "The student, then. A box cutter was found in his possession on September 28th. Found where, exactly?" "In his art supply bag." "During what class?" "Advanced sculpture." "Taught by whom?" Morrison consulted his notes. "Mr. Hendricks." Elena opened her folder. "I have here the Art Department supply log, dated September 28th, signed by Mr. Hendricks himself. Item checked out. Box cutter, number 17. Student name, Marcus Mercer. Purpose, Advanced Sculpture Project, approved by instructor. Return date, October 5th. The silence that followed was beautiful, devastating. "The box cutter in question," Elena continued, "was school property, checked out through proper channels, for a school-approved project, by a student with a documented history of responsible behavior. The only irregularity is that the return was not properly logged, which is an administrative failure by the art department, not a disciplinary violation by my client." Morrison's face had gone pale. The board members were exchanging glances, the kind of glances that said, "We're going to get sued, aren't we?" "We'd like to discuss a resolution," the school counsel said quickly. "Perhaps a brief recess to review these documents." "I'd prefer we resolve this now." Ivory spoke for the first time, her voice quiet but carrying. "My son has missed 4 days of school already. His academic standing is being affected. His college applications are at risk. Every day this drags on is a day of damage to his future." "Ma'am, we understand your concerns." "Do you? Because from where I'm sitting, It looks like you accused a 14-year-old honor student of violating school policy for possessing school property that he checked out through school procedures for a school project. At what point did anyone think to verify those basic facts before threatening expulsion? Marcus squeezed her hand under the table. A small pressure that said thank you and I love you, and please don't get me in more trouble all at once. The hearing lasted another 40 minutes, but the outcome was decided. Charges dismissed, record expunged, school apologized for the miscommunication and any inconvenience caused. The words tasted like ash, inadequate, institutional, designed to minimize rather than acknowledge. But Marcus was cleared. That was what mattered. Outside, in the parking lot, he turned to her with a question in his eyes. "Mom, how did you know to get those records? How did you know to check the supply log?" Ivory pulled him into a hug. Her son, her baby, 6 inches taller than her now, but still her child. "I'll explain everything. Soon. I promise." "You keep saying that. Soon. What does that mean?" "It means—" She pulled back, held his face in her hands. "It means your mother is handling something big. And when it's done, I'll tell you all of it. But right now, I need you to trust me. Can you do that?" He searched her eyes. Whatever he found there was enough. "Yeah, Mom. I trust you." This story isn't over, and the biggest reveal is still coming. If you want to see what happens when she walks into that state bar hearing, keep watching. 4 months later, February 2025. The State Bar of Georgia occupied a building in downtown Atlanta that managed to be both imposing and bland. Gray stone, tall windows, the architectural language of institutional authority. Ivory had been here before, many times, in her capacity as a civil rights attorney. Never as a complainant. Never with this much at stake. The disciplinary hearing room was smaller than she'd expected. More intimate. A long table for the panel. 3 attorneys appointed by the bar, each with the stern expression of people who'd heard every excuse, seen every lie, developed immunity to the sob stories that guilty lawyers always seem to produce at these moments. A smaller table for the respondents, a witness stand, recording equipment to document everything. Hartwell and Associates had come in force. Bradley sat at the respondents' table, flanked by Derek Foley and Heather Ashby. Claudette Vance was there too, slightly apart, her own attorney beside her, already distancing herself from the others, already preparing to cut a deal. Judge Raymond Pemberton had taken a seat in the back row, observer status, his retired status supposedly insulating him from direct involvement. They had hired Marcus Tao, not his real name, but his type, an expensive defense attorney from a prestigious downtown firm. His suit probably cost more than Ivory's entire outfit. His confidence probably cost even more. This complaint is baseless harassment. His opening statement was smooth, practiced. A disgruntled non-client attempting to damage a reputable firm's reputation. My clients deny all allegations of discriminatory practice and stand ready to demonstrate that their intake procedures comply fully with all applicable rules and regulations. Caleb Ruiz, the bar investigator who'd handled the case, shuffled papers at his table. He'd been thorough. Ivory had to give him that. Months of interviews, document requests, subpoenas. The kind of careful, methodical work that didn't make headlines but built cases that held up. The complainant filed this action in October of last year, Ruiz said. The Office of General Counsel has conducted a full investigation. We're prepared to present our findings. The panel chair nodded. Let's proceed. The door at the back of the room opened. Ivory walked in. She was different now, suit tailored, briefcase leather, posture straight with the confidence of someone who'd spent 20 years in courtrooms. No more faded blouse, no more scuffed shoes, no more performance of poverty designed to expose their prejudice. Bradley's reaction was immediate and visceral. He half rose from his chair, face contorting, finger pointing. You! What is she doing here? Mr. Hartwell, please remain seated. The panel chair's voice was firm. Ma'am, identify yourself for the record. Ivory approached the complainant's table, set down her briefcase, faced the panel. My name is Ivory Mercer. I'm a licensed attorney, member of the Georgia State Bar since 2006. JD from Howard University School of Law. Formerly Deputy Chief of the Civil Rights Division at the Georgia Attorney General's Office. Silence. The kind of silence that happens when a room full of lawyers realizes they've underestimated someone catastrophically. More relevantly, Ivory opened her briefcase and removed a document. I am the current managing partner and sole owner of Mercer Legal Group, LLC. 3 months ago, my firm completed the acquisition of Hartwell & Associates for $14.2 million. The transaction closed October 15th. I have been the legal owner of that firm for the past 4 months. She set the acquisition agreement on the table. Let them see it. Let them process it. Bradley's face had gone white. Heather looked like she might be sick. Derek was frozen, his Harvard education apparently not having prepared him for this particular scenario. Even Marcus Tao seemed momentarily at a loss. His client had just discovered that the woman they'd been abusing was, in fact, their boss. What you witnessed in October, Ivory continued, was not a random woman seeking legal services. It was an authorized due diligence audit conducted by the firm's incoming owner. I was legally entitled to be on that property. I was legally entitled to access all records, and I was documenting discriminatory practices that I discovered during acquisition review. Judge Raymond stood up in the back row. This is outrageous. This woman conducted some kind of sting operation? That's entrapment. This entire proceeding should be dismissed. With respect, Your Honor, Ivory's voice was ice, and I use that title loosely given you've been retired for 7 years. Entrapment is a defense available only in criminal proceedings and applies only to government actors inducing someone to commit a crime they wouldn't otherwise commit. I'm a private citizen. I induced no one. I simply observed behavior that occurred naturally. You lied about who you were. I withheld information. There's a legal distinction I'd be happy to explain if the panel requires it. She turned back to face the room. I never made a false statement of material fact. I presented myself as a potential client seeking services, which I had every right to do as part of due diligence for a business acquisition. Nothing I did violated Georgia law or bar rules. What your clients did, however, she opened her briefcase again, folder after folder, each one a bomb. Exhibit A, Statistical Analysis of Intake Decisions. 847 potential clients over 18 months. Black clients approached, 312, accepted, 23, 7.4%. White clients in the same income bracket, 68% acceptance rate. The disparity is not random, it is not coincidence, it is systematic discrimination in violation of Rule 8.4 of the Georgia Rules of Professional Conduct. She set the folder down, reached for the next. Exhibit B, internal email from Claudette Vance to Heather Ashby, dated October 14th, 4:47 p.m. Quote, just created a file note backdated to this morning, should cover us if she complains. Made sure to flag her as aggressive. End quote. This is document fabrication in furtherance of discriminatory practice. The email was recovered from firm servers to which I have lawful access as the firm's owner. Claudette made a small sound, halfway between a gasp and a sob. Her attorney was already whispering in her ear, probably explaining how bad this was about to get. Exhibit C, testimony from Fern Holloway, paralegal at Hartwell & Associates for 3 years. Ms. Holloway documented 74 instances of discriminatory intake denials. Her statement is sworn and notarized. She is available to testify under subpoena if the panel requires it. Exhibit D, security footage from the firm's lobby, October 16th, showing my interaction with Mr. Bradley Hartwell III. During this interaction, Mr. Hartwell physically grabbed my arm and used threatening language. Additional footage from my personal recording shows a subsequent confrontation in the parking garage, where Mr. Hartwell threw a punch that grazed my ribs. I have medical documentation of the resulting bruise. She set out photographs. The bruise, purple and ugly. The timestamp. The doctor's note. Exhibit E, comparative intake data from October 15th. On the same day I was removed from the premises by security, a white woman named Jennifer Collins walked in without an appointment. Same income bracket as me. Same type of case. School disciplinary matter for her daughter. Ms. Ashby greeted her warmly, offered coffee, and scheduled a consultation for the following day. Ivory pressed play on her laptop. The lobby footage appeared on the hearing room screen. Heather smiling, welcoming, professional. Everything she hadn't been with Ivory. Ms. Ashby? Ivory turned to face the receptionist directly. The day you turned me away, you told me the firm serves a certain clientele. You said you had a reputation to maintain. You said I didn't fit. Would you like to explain to the panel what exactly I didn't fit? Heather looked at her attorney. Her attorney shook his head slightly. I'd like to exercise my right to remain silent. This isn't a criminal proceeding, Ms. Ashby. You don't have that right here, but your refusal to answer is noted for the record. The panel chair leaned forward. Ms. Mercer, the evidence you've presented is substantial. Does the complainant have anything further? One more exhibit, Your Honor. Ivory removed a final folder. Exhibit F. Pattern of conduct over time. This is not an isolated incident. This is not a few bad actors. This is a systematic practice embedded in the firm's culture, endorsed by its leadership, and protected by its institutional structure. The partners knew. The office manager participated, the attorneys enforced, and a retired judge, she looked directly at Raymond Pemberton, provided the credibility of his former position to legitimate the whole rotten system. Raymond stood up, face purple with rage. I had nothing to do with intake decisions. I'm of counsel. I don't even work there full-time. Of counsel. The title that provides prestige without accountability. Ivory's voice didn't rise, but it carried. You sat in that lobby and called me a con artist. You said people like me always claim discrimination. You told Bradley Hartwell to let me go because I wasn't worth the trouble. Your words are on the security footage, Your Honor. Would you like me to play them? The silence that followed was devastating. I think, the panel chair said slowly, we'll need to take a recess to review all of this evidence. This hearing will reconvene tomorrow morning at 9 a.m. All parties are ordered to remain available. The recess stretched into evening, then overnight. Ivory sat in her hotel room, case files spread across the bed, preparing for tomorrow's continuation. Her phone buzzed with messages, from Elena Torres, from Fern Holloway, from colleagues who'd heard rumors and wanted confirmation. At 11:47 p.m., a new email arrived, from unknown sender at protonmail.com to Mercer@mercerlegal.com. Subject, no subject. You think you won something. You exposed some low-level employees. Congratulations. But Hartwell was just one firm. The network is larger than you know, and now they know who you are. Watch your back, counselor. Ivory stared at the screen. Read it twice. 3 times. Someone was watching. Someone beyond Bradley and Heather and Derek, beyond the small-time bigotry of a family law firm in Atlanta. Someone who saw her as a threat. Someone who wanted her to know it. She saved the email, documented the timestamp, added it to the evidence file. Then she closed her laptop and turned off the light. Tomorrow would bring answers, some of them, at least. The state bar would issue preliminary findings. Suspensions would be handed down, terminations announced, compliance monitoring established. It would be something, not everything, but something. And the fight was just beginning. The morning arrived gray and cold. February in Atlanta, carrying that particular chill that seeped through clothing and settled into bones. Ivory stood at the window of her hotel room, coffee untouched on the desk behind her, watching the city wake up below. Traffic crawled along Peachtree Street. Pedestrians hurried past with their heads down, collars turned up against the wind. Her phone had been buzzing since 6 a.m. Messages from colleagues, from reporters who'd somehow gotten wind of the hearing, from numbers she didn't recognize. She'd ignored them all. Today required focus. Today required everything she had. The anonymous email from last night still glowed on her laptop screen. She'd read it a dozen times, parsed every word, tried to identify patterns in the phrasing that might reveal the sender. Nothing. Whoever had written it knew how to stay hidden. But they'd made a mistake. They'd revealed themselves, not their identity, but their existence. The network they mentioned. The implication that Hartwell was just one node in something larger. That information was valuable, even if she didn't yet know how to use it. Her phone buzzed again. This time she looked. Fern Holloway. They're saying Bradley didn't come home last night. His wife called the office looking for him. Ivory typed back. Where is he? No one knows. His attorney is here. Bradley isn't. Interesting. A man facing professional ruin, possibly criminal charges, suddenly disappearing. Flight or something worse? She'd find out soon enough. The hearing was scheduled to reconvene at 9. She had 2 hours. 2 hours to prepare for whatever came next. Chapter M. The state bar building felt different this morning. Charged, electric, the way courthouses feel when something significant is about to happen. More people in the hallways, more whispered conversations, more eyes tracking Ivory as she walked toward the hearing room. Caleb Ruiz intercepted her at the door. We have a problem. His voice was low, urgent. Bradley Hartwell hasn't appeared. His attorney is requesting a continuance. On what grounds? Medical emergency. Apparently he checked himself into a psychiatric facility last night. Voluntary commitment. His lawyer says he's not competent to participate in proceedings. The move was transparent, a delay tactic dressed up as a mental health crisis. Ivory had seen it before. Powerful men facing consequences, suddenly discovering they were too fragile to face them. What's the panel's position? They're deliberating now, but here's the thing. Ruiz glanced around, lowered his voice further. Judge Pemberton filed a motion this morning. He's arguing that the entire complaint should be dismissed because of your deceptive conduct during the audit. He's calling it fraud. Fraud? Ivory almost laughed. On what theory? He's claiming you obtained access to firm records under false pretenses, that the acquisition was a pretext for gathering evidence, that you never intended to operate the firm legitimately. I've been operating the firm for 4 months. I've retained all employees except those facing discipline. I've maintained all client relationships. How exactly is that not legitimate? I know, it's a weak argument, but Pemberton has friends on the Judiciary Committee. He's trying to make this political. Of course he was. That's what men like Pemberton did when they couldn't win on the merits. They changed the game, moved the goalposts, called in favors from people who owed them, the system protecting its own. Let him try, Ivory said. I have documentation of every business decision I've made since October. Revenue is up 12%. Client satisfaction scores are the highest in the firm's history. If that's fraud, I'd like to see what success looks like. Ruiz nodded slowly. The panel's ready. They want to proceed with available respondents. Heather Ashby, Derek Foley, Claudette Vance. Bradley's portion will be severed and handled separately. And Pemberton? His motion will be heard after the main proceedings. He's not a formal respondent. He's of counsel, technically an independent contractor. His liability is limited. His liability may be limited. His culpability isn't. The hearing room was fuller than yesterday. Word had spread. Attorneys from other firms had come to watch, some out of curiosity, some out of schadenfreude, a few perhaps out of genuine interest in the legal questions at stake. A reporter from the Daily Report sat in the back row, notebook open, pen moving. Heather Ashby looked like she hadn't slept. Dark circles under her eyes, hair slightly disheveled, the polish of yesterday replaced by something raw. She sat alone at the respondents' table. Derek Foley had been moved to a separate section, his attorney having successfully argued that his interests diverged from the others. Claudette Vance wasn't there at all. Her chair sat empty, a name placard marking where she should have been. "Where's Ms. Vance?" the panel chair asked. Her attorney stood. Your Honor, my client has accepted a consent agreement with the Office of General Counsel. She's waived her right to hearing in exchange for... The terms of consent agreements are confidential until finalized. The panel chair's voice was sharp. We'll proceed without her. A consent agreement. Claudette had cut a deal. Probably cooperation in exchange for reduced sanctions, testimony against the others, access to documents she'd hidden, information about how deep the rot went. Smart move. The first rat off a sinking ship. The panel chair turned to the room. This hearing will proceed with the matter of Heather Ashby and, separately, Derek Foley. The matter of Bradley Hartwell III has been severed pending medical evaluation. Are the parties ready? Marcus Tao, representing what remained of the defense, rose slowly. He looked tired too. Your Honor, before we proceed, I'd like to renew my objection to the complainant's standing. Ms. Mercer obtained her evidence through deception. She misrepresented herself to gain access to my client's workplace. The fruit of that poisonous tree should be excluded. Mr. Tao, we addressed this yesterday. Ms. Mercer was the lawful owner of the firm at the time of the incidents in question. She had every right to be on the premises and to access firm records. There was no misrepresentation. She simply didn't volunteer information she wasn't asked to provide. Your objection is overruled. Then I'd like to call a witness. Someone who can speak to Ms. Mercer's true motivations in this matter. The panel chair frowned. This is a disciplinary hearing, not a trial. Witness testimony is at the panel's discretion. Who do you wish to call? Judge Raymond Pemberton. The room shifted. Pemberton, who had been sitting quietly in the back row, straightened in his chair. His expression was unreadable, but something flickered in his eyes. Satisfaction, perhaps, at being given a platform. Your Honor, Judge Pemberton is not a party to these proceedings. His testimony would be irrelevant. On the contrary, Toe's voice gained confidence. Judge Pemberton has 45 years of experience in Georgia's legal community. He can speak to the standards of professional conduct, to the norms of client intake, and to whether Ms. Mercer's actions constitute the kind of sting operation that should be condemned rather than rewarded. The panel conferred briefly. Then the chair nodded. We'll allow limited testimony. Judge Pemberton, please take the stand. Raymond Pemberton walked to the witness stand with the measured pace of a man who'd spent decades commanding courtrooms. He settled into the chair, adjusted his jacket, folded his hands in his lap. The posture of authority, the performance of credibility. Judge Pemberton. Tao approached respectfully. How long have you been associated with Hartwell and Associates? 7 years, since my retirement from the bench. In your time there, have you ever witnessed discriminatory intake practices? Never. The word came out firm, absolute. Hartwell and Associates serves clients based on the merits of their cases and their ability to pay. Period. Any suggestion otherwise is a fabrication designed to damage the firm's reputation. What about the statistical disparities Ms. Mercer presented yesterday? The difference in acceptance rates between black and white clients? Statistics can be manipulated to show anything. Pemberton's voice dripped with condescension. What Ms. Mercer failed to mention is that many of the black clients she counted as rejected were referred to other firms better suited to their needs. That's not discrimination. That's responsible client management. Ivory made a note. Referred to other firms. She had the data on that too. 93% of rejected black clients received no referral at all. The lie was verifiable. And what about Ms. Mercer's conduct? Her decision to pose as an ordinary client while secretly recording interactions? Disgraceful. Pemberton turned to face the panel directly. In my 45 years of practice, I've never seen such underhanded tactics. This woman purchased a law firm not to practice law but to manufacture a discrimination case. She came in dressed like... He caught himself, but not quickly enough. The pause was damning. Dressed like what, Judge Pemberton? Dressed inappropriately for a professional environment. Could you be more specific? Another pause. Pemberton's jaw tightened. He knew he'd stepped into a trap but couldn't find his way out. She was wearing casual clothes, jeans, a blouse that had seen better days. She looked like... Again the pause. Again the unfinished thought hanging in the air like an accusation. She looked like what, Judge? She looked like someone who couldn't afford our services. And that's why she was turned away? Because of how she looked? I didn't say that. You implied it. Toe seemed to realize his witness was doing more harm than good. No further questions. The panel chair turned to Ivory. Ms. Mercer, would you like to cross-examine? Ivory rose slowly. She'd been waiting for this moment. Judge Pemberton, you stated that Hartwell and Associates serves clients based on the merits of their cases. Is that correct? That's correct. And you stated that many black clients were referred to other firms better suited to their needs. Also correct? Yes. I have here a spreadsheet of all intake decisions from January 2023 to October 2024. Of the 289 black clients who were rejected during that period, exactly 17 received documented referrals to other firms. 17 out of 289. That's 5.8%. Would you like to revise your testimony? Pemberton's face reddened. I wasn't aware of the specific numbers. You've been of counsel at the firm for 7 years. You attend weekly partner meetings. You have access to all firm records, and you weren't aware that 94% of rejected black clients were simply turned away with no assistance. The intake process isn't my area of responsibility. No? Then let's talk about what is. Ivory pulled another document from her folder. I have here an email from March 2023 from Bradley Hartwell to you. Subject line, intake procedures. Shall I read it aloud? Pemberton's composure cracked. Just for a moment, a flash of fear behind the judicial mask. That email is privileged. You're not a practicing attorney at the firm. You're of counsel, an independent contractor. Attorney-client privilege doesn't apply to your communications. And even if it did, I own the firm. Privilege belongs to the client, and I've waived it. She read from the document. Ray talked to our intake coordinator about the screening issue. She understands the parameters now. Certain clients create more problems than they're worth. Thanks for the suggestion about the documentation system. If we ever get audited, we'll be covered. End quote. Pemberton's face had gone from red to white. What documentation system was Mr. Hartwell referring to, Judge? I don't recall. You don't recall a conversation about creating a system to document the rejection of certain clients? A system you suggested? I may have made some general comments about record keeping. That's hardly... The intake note that was fabricated about me, the one dated October 14th, time-stamped before I even arrived at the building, was that part of the documentation system you helped design? I had nothing to do with that. But you knew about it. I knew nothing about Judge Pemberton. Ivory's voice hardened. You stood in that lobby on October 16th and called me a con artist. You said people like me always claim discrimination. You told Bradley Hartwell to let me go because I wasn't worth the trouble. Those words are recorded. Are you going to tell this panel you didn't know what was happening in that firm? That you, a man who spent 30 years on the bench, who built a career on evaluating evidence and detecting lies, had no idea that the firm you worked for was systematically discriminating against black clients? The silence stretched. Pemberton's mouth opened, closed, opened again. No words came out. No further questions. If you think Judge Pemberton is going to face real consequences for this, keep watching, because the system has one more trick up its sleeve. Chapter. The hearing broke for lunch at noon. Ivory sat alone in a conference room, documents spread before her, untouched sandwich growing stale on its wrapper. Her ribs still ached from Bradley's punch 3 days ago, 4 months ago now, but the memory was fresh, the bruise long healed, but the violation permanent. The door opened. Fern Holloway slipped inside, closing it quickly behind her. They found Bradley. Ivory looked up. Where? Airport. He was trying to board a flight to Costa Rica. TSA flagged him. Apparently, there's a hold on his passport. Something about child support arrears from his first marriage. Convenient. It gets better. When they detained him, he had a briefcase full of documents. Firm financials, client lists, internal memos, and cash. $60,000 in cash. Ivory processed this. Bradley had been running, not just from the hearing, from something bigger. $60,000 in cash suggested planning, preparation, the expectation of extended absence. And the documents. What kind of internal memos? I don't know yet. The bar's investigator is trying to get access, but one of the TSA agents mentioned something about network communications, whatever that means. Network. The same word from the anonymous email. The network is larger than you know. Where is he now? Being transported back. He'll be at the county jail by this evening. His attorney is trying to get him released, but the flight risk is pretty obvious at this point. Ivory stood, gathered her papers. The hearing would resume in an hour. New evidence, new possibilities, new threads to pull. Fern, thank you for everything. I haven't done anything yet. You've done more than you know. When this is over, when the dust settles, there's going to be a position open at the firm. Senior paralegal. Better pay, better hours, better everything. It's yours if you want it. Fern's eyes widened. You'd do that? After everything? You kept records when no one else would. You believed something was wrong when everyone around you was pretending it wasn't. That's worth more than a job title. Ivory paused at the door. But first, we have to finish this. The afternoon session began with a bombshell. Caleb Ruiz approached the panel with new documents. Papers recovered from Bradley's briefcase at the airport, released to the bar under emergency provisions. These communications, Ruiz said, appear to document a coordinated effort among several law firms to share information about problem clients. The term is used repeatedly, and context makes clear it refers primarily to minority clients who might file discrimination complaints. The room erupted. Attorneys in the gallery whispered urgently to each other. The reporter's pen moved faster than ever. Heather Ashby looked like she might faint. We're requesting an expansion of this investigation, Ruiz continued. The documents reference at least 4 other firms by name. If these allegations are accurate, we're looking at a conspiracy that extends well beyond Hartwell and Associates. The network. It was real, and Bradley, in his desperation to flee, had accidentally exposed it. Marcus Tao rose, face ashen. Your Honor, I need to confer with my remaining clients. This development changes things. You have 30 minutes. The recess that followed was chaos. Attorneys huddled in corners, making frantic phone calls. Heather Ashby's lawyer pulled her into a side room, voices raised behind the closed door. The reporter was already on his phone, probably calling in the story. Ivory sat still in the middle of it all, watching, waiting. The pieces were falling into place. Not the way she'd planned, but falling nonetheless. Derek Foley approached her table. His usual confidence was gone, replaced by something that looked almost like fear. Can we talk? Off the record? Nothing is off the record in a disciplinary hearing. Then consider it an informal conversation between colleagues. Ivory studied him. Harvard Law, fast-tracked for partner, the kind of young lawyer who'd learned to play the game without ever questioning the rules. Now those rules were collapsing around him. What do you want, Mr. Foley? I want to know if there's a way out of this. For me, specifically. He sat down across from her, uninvited. I followed orders. I did what I was told. The intake policies, the documentation system, that all came from Bradley and Pemberton. I just implemented what they designed. The Nuremberg defense, classic. That's not... He caught himself, took a breath. I'm not saying what happened was right. I'm saying I wasn't the one who made it happen. I was an associate. I did what the partners told me to do. Isn't there some recognition for that? Some mitigation? You cited a non-existent policy to turn me away. Section 3.2, income verification. You invented that on the spot. I was told to find a reason. Any reason. Bradley said what? Derek hesitated. Ivory could see the calculation happening. How much to reveal, what might help him, what might make things worse. The desperate arithmetic of a man trying to save himself. He said certain clients weren't welcome. He said we needed to be creative about enforcement. He said if anyone pushed back, we should escalate until they left. And if that didn't work, he trailed off. If that didn't work, what? He said there were other ways to handle problems. He didn't specify. But the way he said it, Derek shook his head. I didn't want to know. But you kept working there, kept turning away clients, kept following orders. What was I supposed to do? I have $200,000 in student loans. My wife is pregnant. I can't just walk away from a job because I don't like the company culture. You could have refused to participate. You could have documented what you saw. You could have reported it to the bar. And destroyed my career? You know how this industry works. You blow the whistle on a firm like Hartwell, you never work in Atlanta again. Maybe never work anywhere. The blacklist is real. Ivory leaned back in her chair. She did know how it worked. She'd spent 20 years navigating those waters, watching talented lawyers choose silence over integrity because the cost of speaking up was too high. The system was designed that way. Punishment for dissent, rewards for compliance, 1,000 small compromises that added up to complicity. Here's what I know, Mr. Foley. You have a choice right now. You can testify truthfully about what you saw, what you did, who gave the orders, full cooperation, complete transparency. That will count for something with the panel. Probably not enough to save your license, but enough to allow for reinstatement eventually. Or, she paused, let the silence stretch. Or you can keep playing defense, keep hoping this goes away, keep believing the people who created this mess will somehow protect you from it. How do you think that's going to work out? He didn't answer. Didn't have to. The answer was written all over his face. I'll testify, he said finally. Whatever you need, whatever it takes. The hearing resumed with Derek Foley on the stand, answering questions he'd never expected to answer, revealing truths he'd never expected to reveal. The intake system had been Bradley's idea, implemented after Judge Pemberton's recommendation. The goal was deniability, create enough documentation to justify any rejection, make the paper trail look legitimate even when the decisions weren't. Certain clients were flagged for enhanced screening, a euphemism everyone understood. The network had been Pemberton's innovation. Monthly meetings at a private club downtown, 8 or 9 firms represented. Information shared about clients to avoid. Problem clients meant different things to different firms. Chronic complainers, fee disputes, malpractice claims. But for Hartwell, it also meant something else. A code everyone understood and no one said aloud. How long has this network existed? Ruiz asked. Since before I joined. At least 6 years, maybe longer. Bradley inherited it from his father. It's how business has always been done. And Judge Pemberton's role? He founded it, back when he was still on the bench. Said it was about protecting the profession from bad actors. But, Derek trailed off. But when I attended my first meeting, I noticed something. Everyone at the table was white, and everyone we discussed avoiding was black or Hispanic or Asian, every single time. The room was silent. Even the reporter had stopped writing, too absorbed in what he was hearing to document it. Did anyone ever object? Question the pattern? Once, a junior associate from another firm, I don't remember his name, he pointed out that our problem client list seemed to have a demographic skew, asked if we were sure our criteria were neutral. What happened? He wasn't invited back, and 3 months later, he was let go from his firm. Performance issues, they said, but everyone knew. Everyone knew what? That you don't question the network. You don't challenge the system. You play along or you get pushed out. Derek's voice cracked. I played along. For 3 years I played along. And I told myself it wasn't really my fault. It wasn't my decision. I was just doing my job. But that's not true, is it? I had a choice. I made it, and people got hurt because of it. The testimony continued through the afternoon, each witness adding another layer to the picture. Heather Ashby, facing suspension and possible disbarment for her role in client screening, offered limited cooperation, enough to confirm what Derek had said, not enough to implicate herself further. Claudette Vance's consent agreement was unsealed, revealing she'd agreed to testify in criminal proceedings against Bradley in exchange for deferred prosecution on document fabrication charges. The fabricated intake note about Ivory, the one time-stamped before she'd even arrived, had been created at Bradley's direct order, using a system designed to backdate documents convincingly. By 5 p.m., the panel had heard enough. "We'll recess until tomorrow morning for deliberation," the chair announced. "Preliminary findings will be issued at that time. All parties should be prepared for disposition." Ivory gathered her papers, exhaustion settling into her bones. 4 months of preparation, 4 days of testimony, and now it came down to 3 attorneys in a room deciding how much justice was enough. She was almost to the door when a hand grabbed her arm. Hard, painful, the grip of someone who'd stopped caring about witnesses. "You think you've won something?" Heather Ashby's face was inches from hers, mascara streaked, professional facade completely gone. Her nails dug into Ivory's skin through her jacket sleeve. "You ruined my life, my career, everything I built for 10 years. Let go of me. Do you know what it's like? To wake up every morning knowing exactly who you are, exactly where you belong, exactly what the rules are, and then some—" She caught herself, but the word hung unspoken between them. "Some woman walks in and tears it all down because she doesn't like how she was treated? You turned away 289 black clients in 18 months. You fabricated documents. You lied to investigators. That's not me ruining your life. That's you ruining it yourself." Heather's grip tightened. "You don't understand anything. This is how it works. This is how it's always worked. The clients we turned away? They found other lawyers. They got their cases handled. No one was actually hurt. Except they were." Ivory pulled her arm free, stepped back, put distance between them. "They walked into your lobby looking for help and walked out believing they didn't deserve it. They went home and told their families that the legal system wasn't for people like them. They learned, one rejection at a time, that their problems didn't matter, that their money wasn't good enough, that they weren't good enough. You didn't just turn them away. You taught them to expect less." Security was approaching now, alerted by the commotion. Heather's attorney was calling her name, trying to intervene before she made things worse. "This isn't over." Heather's voice was a hiss. "The network has lawyers you haven't even heard of, resources you can't imagine. You think you exposed something? You scratched the surface, and now they know your name." She let herself be led away, still glaring over her shoulder. Ivory watched her go, Heather's words echoing in her mind. "They know your name." Ciao. That night, Ivory sat in her hotel room with Fern Holloway and Caleb Ruiz, documents spread across every surface. The network files from Bradley's briefcase had been copied, analyzed, cross-referenced with bar records and court filings. 8 firms, 8 managing partners, a decade of coordinated discrimination hidden behind professional courtesy and gentlemen's agreements. "We can prosecute maybe half of them," Ruiz said. "The others have enough deniability to make charges difficult. They attended meetings, but we can't prove they implemented the policies." "What about the emails? The client lists they shared?" "Some of them claim it was legitimate referral coordination. Firms share client information all the time. It's not inherently illegal. Proving discriminatory intent requires more than attendance at meetings." Fern looked up from her laptop. "But Bradley's notes are explicit. He wrote down who said what at each meeting. Specific quotes, specific decisions, specific clients discussed." "Bradley's notes are hearsay if he's not available to authenticate them. And right now, he's in a psychiatric hold, claiming he's not competent to testify." The convenient breakdown. The system protecting its own, even now. "So what can we actually do?" Ivory asked. Ruiz sighed. "Hartwell, Ashby, and Foley are done. Bradley's facing criminal charges for assault, flight, and obstruction. Pemberton will get a public reprimand. His retired status limits the bar's jurisdiction, but his reputation is destroyed. The other firms, he shook his head. Warnings, monitoring, maybe consent agreements for the most egregious. But no disbarments, no criminal referrals, not enough evidence. That's not justice. No, it's the law. There's a difference. Ivory stood, walked to the window, looked out at the city lights. Somewhere out there, partners at other firms were making phone calls, coordinating responses, preparing their defenses. The network was wounded but not dead. It would adapt, evolve, find new ways to accomplish old goals. But something had changed. The pattern was documented now. The names were known. The next time a black client was turned away, the next time a suspicious intake decision was made, there would be a record to compare it against. A baseline. Evidence that the problem was real and systemic and deliberate. It wasn't enough. But it was a start. What about the anonymous email? Fern asked. The threat? We traced the IP to a VPN in Eastern Europe. Dead end. Whoever sent it knows how to cover their tracks. So they're still out there, watching. Yes. Ivory turned from the window. They're watching. And now we're watching back. The verdict is about to drop, but you won't believe who walks away free. Stay with me. Morning brought rain again, heavier this time, drumming against the windows of the State Bar building like impatient fingers. The hearing room was packed, every seat filled, observers standing against the walls, the weight of anticipation pressing down on everyone present. Ivory sat at the complainant's table, hands folded, face composed. Whatever happened in the next hour would define not just this case, but the message sent to every other firm contemplating similar practices. Too lenient, and the network would learn it could weather exposure. Too harsh, and the backlash would paint the bar as overreaching, the respondents as martyrs. The panel entered in single file. 3 attorneys, faces professionally blank, carrying folders thick with deliberation notes. They took their seats with the careful movements of people who understood the gravity of what they were about to do. This panel has reviewed all testimony and evidence presented over the past 4 days, the chair began. We have reached preliminary findings on each respondent. Final disposition will follow a 30-day comment period, but the findings themselves are effective immediately. She opened her folder. In the matter of Heather Ashby, this panel finds sufficient evidence of violations of Georgia rules of professional conduct, specifically Rule 8.4d, conduct prejudicial to the administration of justice. Ms. Ashby's role in screening clients based on race and her participation in fabricating documentation to justify discriminatory denials represents a fundamental breach of professional ethics. Heather sat motionless, her attorney's hand on her arm. The panel recommends suspension of Ms. Ashby's paralegal certification for a period of 3 years, with reinstatement contingent on completion of 40 hours of continuing education in civil rights law and professional ethics. Additionally, Ms. Ashby is permanently barred from supervisory roles involving client intake at any Georgia law firm. Suspension, not permanent revocation. Ivory had expected as much. Heather wasn't a lawyer. The bar's jurisdiction over non-attorney staff was limited. 3 years was significant but survivable. In the matter of Derek Foley. Derek straightened in his chair, jaw tight. This panel finds sufficient evidence of violations of Rules 8.4d and 3.4a, conduct prejudicial to justice and obstructing access to evidence. However, the panel also notes Mr. Foley's substantial cooperation with the investigation and his testimony regarding systemic practices at the firm. The panel recommends suspension of Mr. Foley's law license for a period of 18 months, with reinstatement contingent on successful completion of professional responsibility remediation and a demonstration of reformed conduct. Mr. Foley's cooperation is noted as a mitigating factor, and the panel declines to recommend permanent disbarment. 18 months. enough to destroy his current career trajectory, but not enough to end his career entirely. Derek's face showed relief and devastation in equal measure, grateful to survive, crushed by what survival would cost. In the matter of Bradley Hartwell III. Bradley wasn't present, still in psychiatric hold, his empty chair a reminder of his flight and failure. This panel finds overwhelming evidence of violations of Rules 8.4b, C, and D, including criminal conduct, dishonesty, and conduct prejudicial to justice. Mr. Hartwell's role as the architect of discriminatory intake practices, his physical assault on a potential client, his attempt to flee the jurisdiction, and his possession of documents suggesting a broader conspiracy all demonstrate a pattern of conduct incompatible with the practice of law. The panel recommends permanent disbarment of Bradley Hartwell III from the Georgia State Bar, effective immediately. Additionally, this matter is referred to the Fulton County District Attorney for consideration of criminal charges. Permanent disbarment, criminal referral, the maximum sanction available. Ivory allowed herself a small measure of satisfaction. Bradley would never practice law again, at least not in Georgia. Finally, in the matter of Judge Raymond Pemberton. Pemberton sat in the back row, face carefully neutral, as if the proceedings had nothing to do with him. Judge Pemberton's status as retired judiciary and of counsel rather than full partner limits this panel's jurisdiction. However, the evidence clearly establishes his role in designing and implementing discriminatory practices at Hartwell and Associates. The panel issues a formal public reprimand to Judge Raymond Pemberton. His conduct is referred to the Judicial Qualifications Commission for review, though we note that the Commission's jurisdiction over retired judges is limited. Additionally, the panel recommends that any law firm employing Judge Pemberton in the future be required to implement enhanced oversight of intake practices. A public reprimand. That was all. Pemberton had spent 45 years building a reputation, and his punishment was a strongly worded letter in his file. He would face no suspension, no disbarment, no criminal referral. His retirement benefits would continue. His social standing would survive, damaged but intact. The system protecting its own until the very end. These findings conclude the disciplinary proceedings against Hartwell and Associates, the chair continued. However, this panel notes with grave concern the evidence of a broader network of coordinated discrimination involving multiple firms. We are referring that evidence to the Office of General Counsel for expanded investigation. The panel also notes the exceptional work of Ms. Ivory Mercer in documenting these practices. While some have questioned her methods, this panel finds that she acted within legal bounds and in service of legitimate professional and business interests. Her acquisition of Hartwell and Associates and subsequent audit represents a novel but permissible approach to exposing discriminatory practices. This hearing is adjourned. Toss. The aftermath was chaos. Reporters cornered anyone who would talk. Attorneys huddled in clusters, processing what they'd heard, calculating implications for their own practices. Heather Ashby was escorted out a side door, avoiding cameras. Derek Foley stood alone by the window, staring at the rain. Ivory was packing her briefcase when Judge Pemberton approached. His face was composed, even pleasant, the mask of judicial temperament that had served him well for decades. Ms. Mercer, a word? She didn't stop packing. Make it quick. I wanted to congratulate you, sincerely. His voice was smooth, gracious, utterly unconvincing. You played a clever game, bought a company, manufactured a case, destroyed careers. Very impressive. I didn't manufacture anything. I documented what was already there. Semantics. He moved closer, lowering his voice. But I wonder if you've considered the full implications of what you've done. The network you exposed. It exists for a reason. Certain clients are genuinely more trouble than they're worth. Certain cases create liabilities that responsible firms should avoid. What you call discrimination, others call risk management. Risk management. Ivory finally looked up, met his eyes. Is that what you called it when you were on the bench? when you were deciding which defendants got bail and which didn't, which sentences were lenient and which were harsh. The mask slipped. Just for a moment, a flash of cold rage behind the pleasant facade. You're making an accusation you can't support. Am I? The network documents reference your time on the bench, favorable dispositions for clients of member firms, enhanced scrutiny for opposing parties. Would you like me to share those references with the Judicial Qualifications Commission? Pemberton's face went pale. Those documents are confidential. They were confidential. Then Bradley tried to run with them and got caught at the airport. Now they're evidence in a criminal investigation. Ivory closed her briefcase, picked it up. You got a public reprimand today. That's all the bar could do. But the DA's office has broader powers, and they're very interested in patterns of judicial misconduct. You can't prove anything. Maybe not, but I can make sure the right people ask the right questions, and I think we both know what they'll find. She walked away, leaving him standing alone in the emptying hearing room. His reputation was destroyed, his network was exposed, his future held nothing but investigations and depositions and the slow unraveling of a career built on corruption. It wasn't prison, it wasn't disbarment, but it was something. 3 weeks later, the offices of Hartwell and Associates, now operating as Mercer Legal Group, Atlanta Division, had been transformed. Same address, same marble lobby, same expensive art on the walls. But the energy was different now. The air itself seemed to move more freely. Fern Holloway sat at the reception desk, nameplate gleaming. Client Relations Manager. She'd been promoted, just as Ivory had promised. Her salary had doubled. Her responsibilities had tripled. She was the first person every client saw when they walked through the door, and she made sure every client felt welcome. Ms. Mercer? She looked up from her computer. Your 2 o'clock is here. Ivory emerged from the corner office, her office now, the one that had belonged to Bradley Hartwell III. She'd kept the furniture but added touches of her own, law books from her first practice, framed photos of Marcus at various ages, a small plant on the windowsill that she somehow kept forgetting to water. The client waiting in the lobby was a black woman in her 50s, clutching a folder of papers, expression uncertain in the way people looked when they weren't sure they belonged. She stood when Ivory approached. Mrs. Washington? I'm Ivory Mercer. Come on in. Are you sure you have time? I know I just walked in. I don't have an appointment. We have time. Ivory smiled, a real smile, warm and welcoming. That's what we're here for. Tell me about your case. They settled into Ivory's office, door closed, the sounds of the city muffled by thick windows. Mrs. Washington's case was familiar, a landlord dispute, housing discrimination, the kind of case that prestigious firms rarely touched because the fees were modest and the clients were poor. My last lawyer dropped me, Mrs. Washington said. Said my case wasn't economically viable, whatever that means. It means they didn't think they'd make enough money to bother. Ivory opened a legal pad, began taking notes. We don't operate that way here. If your case has merit, we take it. Fees are scaled to what you can afford. If you can't afford anything, we work something out. That doesn't sound like good business. It's not about business. It's about what lawyers are supposed to do. Ivory looked up from her notes. Now, start from the beginning. When did the problems with your landlord first start? That evening, Ivory sat in her apartment with Marcus, Chinese takeout containers spread across the coffee table. He was 16 now, 2 years since the expulsion hearing, 2 years of growth and change and the slow healing that time sometimes brought. Mom, he set down his chopsticks. People are still talking about you, at school, online. What are they saying? That you bought a racist law firm just to shut it down, that you're some kind of vigilante, that you're either a hero or a lunatic, depending on who you ask. Ivory laughed, the first real laugh she'd had in weeks. Which do you think? I think you're my mom, and I think you did something that mattered. He paused, choosing his words carefully. But I also think You could have just not bought the firm. You could have reported them to the bar without doing the whole undercover thing. Why did you do it that way? It was a fair question, one she'd asked herself many times. Because reporting doesn't always work, she said finally. Because the bar protects its own. Because without evidence, real evidence, documented evidence, evidence that couldn't be explained away or covered up, nothing would have changed. They would have gotten a slap on the wrist and gone right back to what they were doing. But you spent $14 million. I spent $14 million on a law firm that's now profitable, that employs 23 people, and that has completely changed how it serves the community. The money wasn't a cost, it was an investment. An investment in what? Ivory considered the question. How to explain something she'd spent her whole career trying to articulate. An investment in showing that it doesn't have to be this way, that the system can change, that one person, if they have the resources and the determination and the willingness to take risks, can make a difference. She reached across the table, took his hand. You know what Bradley Hartwell said to me? In that parking garage, right before he tried to punch me? He said I was nothing, a nobody, a welfare case looking for a handout. What did you say? I didn't say anything, I just left. But I thought, this is what they think about us. This is what they really believe. And I wondered how many people had stood where I was standing, heard what I heard, and had no way to fight back. No resources, no knowledge, no power. So you bought the power. I bought the platform. The power was always there. It just needed a way to express itself. She squeezed his hand. You're going to have moments like that, baby. Moments when someone looks at you and sees what they expect to see instead of who you actually are. When that happens, you have choices. You can internalize it, believe what they believe about you. You can fight it openly, confront it head-on. Or you can do what I did. Document everything, build your case, wait for the right moment, and then show them exactly how wrong they were. That sounds exhausting. It is, but it works. Later that night, after Marcus had gone to bed, Ivory sat in her home office reviewing the files that had accumulated over the past 3 weeks. The expanded investigation Ruiz had mentioned was moving slowly. Bureaucratic caution, limited resources, the usual obstacles. 3 of the 8 network firms had retained expensive lawyers and were fighting every subpoena. 2 others had quietly dissolved, their partners scattering to other states, other practices, other opportunities to continue their work unobserved. And then there was the email. It had arrived that morning from the same anonymous address as before. You won a battle, not the war. The network has existed for decades. It will exist for decades more. Your firm is being watched. Your clients are being noted. Your family is known. This is not a threat. This is information. Use it wisely. Ivory had forwarded it to Ruiz, to her own security consultant, to the FBI agent who'd taken an interest in the case. None of them had found anything useful. Same VPN, same dead ends, same professional anonymity. But the message itself told her something. Whoever was writing wasn't trying to scare her into silence. They would have led with threats if that were the goal. They were trying to warn her, to inform her, to let her know that the game wasn't over, that the stakes remained high, that the system she'd exposed was larger and more resilient than one successful case could dismantle. Use it wisely. She would. She had to. Because somewhere out there, the network was still operating. Other firms were still turning away clients based on skin color. Other judges were still trading favorable rulings for professional courtesy. Other systems were still grinding down the people they were supposed to protect. One case couldn't change all of that. But one case could establish precedent, could show that exposure was possible, could demonstrate that the people with power weren't as invulnerable as they believed. The fight wasn't over. It was barely beginning. 6 months later. The Atlanta Journal-Constitution ran a story on page 1. State bar investigation expands to 8 firms. The article detailed the network's operations, the pattern of discrimination, the web of professional relationships that had enabled it. 3 more partners had been suspended. 2 firms had agreed to consent decrees requiring diversity monitoring. 1 had been sold to a minority-owned practice group that promised to transform its culture entirely. Ivory read the article over breakfast, noting the careful language, the legal hedging, the way the story presented the network as an aberration rather than a symptom. It wasn't the whole truth, but it was more truth than anyone had expected to see in print. Her phone buzzed, a text from Fern. "News crew outside the office. Want me to handle?" "I'll be there in 20 minutes. The drive from Decatur to downtown took longer than usual. Traffic backed up on I-85 for no apparent reason, the daily frustration of Atlanta's infrastructure straining under demands it was never designed to meet. Ivory used the time to think, to plan, to consider what she would say when the cameras were pointing at her. The firm's parking garage was underground now, a new security measure, implemented after the threatening emails had continued to arrive with disturbing regularity. She parked in the spot marked Reserved Managing Partner, gathered her things, took the elevator up. The lobby was full of flowers. Dozens of arrangements, delivered over the past week from clients, from other attorneys, from community organizations that had read about the case and wanted to express support. Fern had given up trying to find places for all of them. They lined the walls, crowded the reception desk, filled the air with competing fragrances. "Popular lady," Fern said as Ivory walked in. "Channel 5 wants a statement, so does CNN, and there's someone waiting in your office." "Who?" She wouldn't give her name. "Said you'd want to see her." Ivory's instincts prickled. After months of anonymous threats, an unidentified visitor wasn't welcome news. But the security team had cleared her, scanned her bag, checked her ID, determined she wasn't carrying anything dangerous. The woman sitting in Ivory's office was white, mid-60s, dressed in the kind of understated expensive clothing that suggested old money and older secrets. She stood when Ivory entered, extended a hand. "Ms. Mercer, thank you for seeing me. My name is Charlotte Pemberton." Pemberton. The name hit like a physical blow. Judge Pemberton's wife? Ex-wife. Divorced 23 years ago, though I kept the name because it opens certain doors. Charlotte's smile was thin, knowing. "I've been following your case with great interest. What you did to Raymond, exposing his little network, destroying his reputation, making sure the whole world knew what kind of man he really is. It was satisfying." Ivory remained standing, hand not extended. "What do you want?" "To help, or more accurately, to finish what you started." Charlotte reached into her bag, produced a thick envelope. Raymond thought he destroyed all the records from his time on the bench. The questionable rulings, the backroom deals, the favors traded for future considerations. But I kept copies. Insurance, you might call it. Protection against a man who had shown what he was capable of. She set the envelope on Ivory's desk. There are 47 cases documented there. 47 instances where Raymond's rulings were influenced by his network connections. Defendants who should have been acquitted but weren't. Plaintiffs who should have won but lost. Justice denied for reasons that had nothing to do with law or evidence. "Why now? You've had these for 23 years. "Because until now, no one would have believed me. I was just the bitter ex-wife, making accusations to hurt her former husband. But you," Charlotte's eyes met Ivory's, "you have credibility. You have evidence. You have a platform. And most importantly, you've already shown that you're willing to use them." Ivory looked at the envelope. 47 cases. 47 families who had been failed by a system they trusted. 47 opportunities to revisit injustice, to reopen wounds, to possibly make things right. Or 47 new battles, each with its own complications, its own obstacles, its own potential for disappointment. "Why do you want to help?" she asked. "What's in this for you?" Charlotte's smile turned cold. "Raymond made my life hell for 15 years. Controlling, manipulative, convinced his position made him untouchable. When I finally left, he used his connections to ensure I got nothing in the divorce. No alimony, no share of the assets we'd built together, nothing but the clothes I was wearing when I walked out the door. He told me I was nothing without him. that no one would ever believe me over a judge. She stood, smoothed her jacket. Proving him wrong is worth more to me than money ever could be. This isn't where the story ends. It's where it really begins. If you want to see justice continue to unfold, hit subscribe and share this story with someone who needs to hear it. The envelope sat on Ivory's desk for 3 days, while she considered what to do with it. 47 cases. Some from 20 years ago, some more recent. Defendants convicted on thin evidence in courtrooms where the judge had already decided the outcome. Civil plaintiffs denied relief because their opponents had better connections. Family court decisions that favored wealth and whiteness over merit and fairness. The statute of limitations had run on most of them. Criminal cases couldn't be retried without new evidence of actual innocence. Civil cases would face procedural hurdles that made reopening nearly impossible, but some, a handful, might still be actionable. Cases where defendants had been convicted of crimes that carried mandatory minimums, where they were still serving time, where new evidence of judicial bias could support appeals based on due process violations. Cases where civil settlements included ongoing obligations that could be challenged if the underlying judgments were tainted. She called Elena Torres, the civil rights attorney who had handled Marcus's case. "I need help, pro bono, the kind of help that might not go anywhere but needs to try anyway." Elena listened as Ivory explained the situation, the documents, the cases, the possibility of relief for people who had been failed decades ago. "You know, most of these won't succeed," Elena said when she finished. "The legal hurdles are significant. And even if we win, what remedy is there? Raymond Pemberton can't be retried. He's not going back on the bench. But his victims can know the truth, can have their cases reviewed, can maybe, finally, have someone say, 'What happened to you was wrong, and it wasn't your fault.'" A long pause. Then, "Send me the files. I'll look at them this weekend." The months that followed were a blur of activity. Elena identified 7 cases with potential for relief, 4 criminal appeals, 3 civil motions. Ivory's firm took on 3 of them. Elena's handled 2. The remaining were referred to law school innocence projects, eager for real-world experience. The first victory came 8 months later. Darnell Washington, no relation to Ivory's client Mrs. Washington, had been convicted of armed robbery in 2009, based largely on eyewitness testimony that had been coached by prosecutors working with Judge Pemberton. Charlotte's documents included a memo discussing how to strengthen the identification process in cases involving problem defendants. The Fourth Circuit agreed that the coaching constituted prosecutorial misconduct. Darnell's conviction was vacated. After 15 years in prison, he walked out into sunlight he barely remembered, into a world that had moved on without him. Ivory was there when he was released, standing in the parking lot of the Federal Correctional Institution, watching as his mother rushed forward to embrace him. The woman was 73 now, gray-haired, walking with a cane, but she moved like someone half her age when her son came through those doors. "Ms. Mercer." Darnell approached her after the initial reunion, his mother still clutching his arm. "My public defender told me about you, about what you did, how you found those documents." "I can't take credit. Someone brought them to me. All I did was make sure they got to the right people." "All you did." He shook his head, a ghost of a smile crossing his face. "Lady, I spent 15 years thinking I must have done something wrong, that I must have deserved what happened to me, that the system wouldn't have convicted me if I was really innocent. And now I find out it was never about me at all. It was about a judge who decided I was guilty before I walked into his courtroom. I'm sorry for what you went through, for how long it took. Don't be sorry, be proud. You did something nobody else was willing to do." He pulled her into a hug, unexpected, overwhelming, the embrace of a man who had forgotten what human warmth felt like. "Thank you for not letting them get away with it." The other cases moved more slowly. 2 of the criminal appeals were denied on procedural grounds, the courts acknowledging the evidence of bias, but ruling that it didn't meet the standards for overturning convictions decades after the fact. One civil motion succeeded, resulting in a settlement that the defendant's insurance company paid quietly to avoid publicity. And Judge Raymond Pemberton, the architect of it all, the man whose corruption had poisoned justice for 30 years, faced his own reckoning. The Judicial Qualifications Commission, armed with Charlotte's documents and the expanded Barr investigation, issued a formal censure, public reprimand, official condemnation, the maximum sanction available for a retired judge who could no longer be removed from a bench he'd already left. It wasn't enough. It would never be enough. But when the censure was announced, Pemberton's face appeared on the evening news, his carefully constructed reputation finally, irrevocably destroyed. He would spend whatever years he had left knowing that everyone knew what he had done, that his legacy was corruption, not justice, that history would remember him not as the respected jurist he'd pretended to be, but as the small, venal man he actually was. Some victories weren't measured in prison sentences or dollar amounts. Some victories were simply truth, finally spoken aloud. 1 year after the original Hartwell hearing, Ivory stood in the conference room of Mercer Legal Group, Atlanta Division, surrounded by the staff she'd built over 12 months of careful hiring. Fern was there, of course, along with 8 new attorneys, 4 from the original Hartwell team who'd passed enhanced ethics screenings, 4 hired from outside with specific experience in civil rights and family law. Support staff filled the remaining seats: paralegals, administrative assistants, client coordinators, the infrastructure of a functioning law firm. "We're at capacity," she said. "Revenue is up 34% from last year. Client satisfaction scores are the highest in the state, and we've taken on more pro bono cases in 12 months than Hartwell did in its entire 40-year history." Applause rippled through the room, pride evident in faces that had once worked for a firm they'd known, deep down, was doing wrong. They had a chance now to be part of something different, something better. "But I want to talk about what comes next," Ivory continued, "because the work isn't finished. The network we exposed is wounded but not dead. The systems that enabled discrimination are still in place. The barriers that keep people from accessing justice haven't magically disappeared." She clicked to a new slide. Statistics on legal representation in Georgia, the percentage of people who faced court proceedings without attorneys, the demographic breakdown of who got help and who didn't, the gap between the ideal of equal justice and the reality of how the system actually functioned. Our job isn't just to run a profitable firm, it's to change the profession, to model what legal practice should look like, to train the next generation of lawyers to do better than the last one. She paused, looking around the room. "Some of you were here when the old practices were in place. You saw what happened. You know what we're fighting against. I need you to help me build something that makes that kind of firm impossible." The faces looking back at her were serious, committed, determined. They had been given a second chance, and they knew it. The question was whether they would use it. That evening, Ivory sat in her office long after everyone else had gone home. The city lights glittered through her window, Atlanta spreading out below her, millions of lives intersecting in ways she would never see, problems she would never solve, injustices she would never know about. Her phone buzzed. A text from Marcus. "Coming home for spring break. Can we talk about internships?" She smiled, typed back, "Always. I know a firm that might be hiring." The door opened. Fern stood in the entrance, coat on, bag over her shoulder, ready to leave but hesitant. "I thought you'd gone home." "I was about to, but there's something you should see." Fern crossed to the desk, set down a printout. "This came through the general intake email about an hour ago." Ivory read the message. "Ms. Mercer, you don't know me, but I know you. I've been watching what you've done with Hartwell, what you've built, the cases you've taken, the people you've helped. I work at a firm in Birmingham. Similar practices, similar problems. I've been keeping records for 3 years, but I don't know what to do with them. I don't have the resources you had. I can't buy the firm I work for. I can barely afford my rent. But I wondered, if I gave you what I have, could you do what you did before? Could you expose them? Could you make it stop? I'm scared. I could lose everything. But I can't keep watching this happen and doing nothing. Please help. A paralegal who wants to be braver. Ivory read it twice, 3 times. Let the words settle into her bones. What do you think? Fern asked. I think the network is larger than one firm, larger than 8 firms, larger than anything we've exposed so far. Ivory looked up at the city lights, at the darkness beyond them, at all the places where injustice flourished in silence. And I think we've barely begun to fight it. So what do we do? Ivory reached for her phone, began composing a reply. We answer. We listen. We help. She paused, fingers hovering over the keyboard. And then we do what we did before. Document everything. Build the case. Wait for the right moment. And show them exactly how wrong they were. She pressed send. Somewhere in Birmingham, a paralegal's phone would buzz with a message that said, I'm listening. Tell me everything. The fight wasn't over. It was spreading. Charutier. The last email from the anonymous sender arrived 2 weeks later. You're making a mistake. The network is not your enemy. The network is the profession. You cannot fight what everyone does. You cannot change what everyone accepts. You can only destroy yourself trying. Walk away. Take your victory. Enjoy your reputation. Let the system correct itself in its own time. This is not a threat. This is advice. The only advice you'll get. Some battles cannot be won. Some mountains cannot be moved. Some systems exist because they serve a purpose, even if that purpose is invisible to you. Last warning. Last chance. Choose wisely. Ivory read it once. Then she hit delete. She had work to do. Epilogue. 1 year later. The annual meeting of the Georgia Bar Association was held that year at the Atlanta Marriott Marquis, the cavernous atrium filled with lawyers in expensive suits, networking their way toward partnerships and corner offices. Ivory was there as a featured speaker. The program listed her topic as Ethical Obligations in Client Intake, Lessons from Recent Disciplinary Actions. Everyone knew what that meant. Everyone knew who she was. She took the podium at 2 p.m., looked out at 500 faces, some curious, some hostile, some genuinely interested in what she had to say. In the back of the room, she spotted Judge Raymond Pemberton, seated alone, watching with an expression that might have been hatred or might have been fear. Thank you for having me, she began. I know my reputation precedes me. The woman who bought a law firm to expose discrimination, the troublemaker who embarrassed the profession, the outsider who didn't play by the rules. Murmurs in the audience. Discomfort. Exactly what she'd intended. But I want to talk today about something more fundamental than my case or any single case. I want to talk about who we are, who we're supposed to be, who we've actually become. She clicked to her first slide. The statistics she'd been gathering for months. Acceptance rates broken down by race, income, zip code. The patterns that emerged when you looked at the data honestly. The legal profession has a problem. Not a few bad actors, not isolated incidents. A systemic, structural problem with how we decide who deserves help and who doesn't. And until we acknowledge that problem, until we stop pretending it's someone else's failure, someone else's firm, someone else's responsibility, nothing will change. The room was silent now, attention focused. I didn't expose Hartwell and Associates because I enjoyed destroying careers. I did it because people were being hurt, real people with real problems, who came to lawyers for help and were turned away for reasons that had nothing to do with law and everything to do with prejudice. And the dirty secret of our profession is that Hartwell wasn't unique. They were just clumsy enough to get caught. She let that land. Watched faces shift, consciences prick, denials form and fade. I'm not asking you to be perfect. I'm asking you to be honest. Look at your own intake practices. Look at who you accept and who you turn away and why. Look at the patterns in your own decisions. And if you find what I found, If you find that certain clients are deemed less worthy for reasons you can't quite articulate, then fix it, before someone else has to fix it for you. She stepped back from the podium. Applause. Scattered at first, then building, not universal but significant. Enough people in that room who recognized truth when they heard it. In the back row, Judge Pemberton rose and walked out. His back was rigid with fury, his hands balled into fists at his sides. He had lost. He knew it. And he couldn't do anything about it except watch the profession that had protected him finally, slowly, begin to change. That night, Ivory drove home through Atlanta traffic, windows down despite the heat, letting the city wash over her. The case was done. The firm was running. The fight continued in 100 small ways that would never make headlines but might, over time, move the needle. Marcus was waiting when she got home. 18 now, heading to college in the fall, Howard Law, following in her footsteps, ready to continue the work she'd started. How was the speech? About what I expected. Some people listened, some people didn't. The ones who didn't will probably keep doing what they've always done. The ones who did... She shrugged. Maybe they'll be different. Maybe they'll at least think about it. Is that enough? The question hung in the air. The same question she'd been asking herself for 2 years, ever since she'd first seen those intake statistics and decided to do something about them. It's a start, she said finally. It's not everything. It's not even close to everything. But it's more than there was before. And sometimes that's all you can do. Make things a little better, a little more fair, a little more honest. And hope that someone else picks up where you leave off. Marcus nodded slowly. I want to help. When I finish school, I want to do what you do. Then do it. But do it your way. Find the battles that matter to you. Use the tools you have. Don't wait for permission or resources or the perfect moment. She put her hand on his shoulder. The system doesn't change because powerful people decide to change it. It changes because ordinary people refuse to accept it. That's what I learned. That's what I hope I taught you. He hugged her, her son, her pride, the reason she'd started this whole journey in the first place. Thanks, Mom, for everything. Don't thank me yet, she smiled. We've still got work to do. Outside, the city hummed with its endless activity. Somewhere, a paralegal in Birmingham was gathering evidence. Somewhere, another firm was turning away clients for the wrong reasons. Somewhere, the network was adapting, evolving, finding new ways to protect old privileges. And somewhere, Ivory Mercer was planning her next move. The fight was far from over, but for the first time in a long time, it felt like they might actually be winning. Moi.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.